Thank you. It's an honour to be here, and thank you, Sally, for acknowledgement of country. And as I'm about to speak about law, I want to remind us, as I usually do at the beginning of these, that the land that we're meeting on has had law for tens of thousands of years and continues to have law. National security law is much newer, though arguably humans have been fighting about territory and access to resources for a very long time. But national security law as a discipline is pretty new. As Danielle said, I've been working in it for nearly 25 years, and gosh, I wish this book was around then. In fact, when I started working in national security law, we had a meeting of all of the national security lawyers. It was a small coffee table. We all fitted comfortably around it. Last year, I gave a presentation at the National Security Law Conference, and it was in a ballroom, and it was packed full of national security lawyers. So there has been a boom in the industry for national security lawyers and national security policymakers, driven by other explosions, but also explosions in the volume of law. And I just want to take a moment to think about how much law there is in this space now. In fact, here's a fun fact, we got through the whole of the Cold War with an ASIO Act that was 5 pages long. More of a pamphlet, really, than a law. It's now 350-ish pages long, more of a weapon than a law. And the Telecommunications Interception Act, initially 7 pages, now more than 700, is more like a sort of weightlifting exercise than a law. So there's been this huge expansion, not only in domestic law, but international law. We've got all these treaties on counterterrorism financing, on the law of the sea, and we've really expanded what we think of as national security law. This book's a really good example. It takes us through some fields that we should expect to be national security law, but some things that are newer, thinking about climate, energy, gender, space. We've really expanded our understanding of the law. The book comes at an important time when I think we're at another sort of growth spurt, if you like, for national security law, as we face what the Director General called extreme levels of foreign interference, espionage and sabotage risks. In 2021, we updated our foreign interference, espionage, sabotage laws, but we're having another look at those now. It's really, as Rebecca said, one of the roles of my office, which was technically, you're right, first staffed in 2011, but actually created in 2010, is to look at our national security legislation and think about whether it remains necessary, proportionate, effective, and has effective protections for human rights. And my office sits independent of the Parliament and makes recommendations to the Attorney and to the Parliament about law reform. And I think the laws that I've been working on in the last year or so and the next year or two give you an indication of the sort of range of things and the range of worries. Because some of my work comes not from just me waking up in the morning and thinking it'd be a nice thing to review, but from the parliamentary committee and the Parliament themselves. Sometimes I think they get a bit nervous about the scope of some of the laws they're passing. And one of the things they do is pop a little clause into my act saying, don't worry, she'll be right, the INSLM will review this. And a few of those have come to roost. So I started in the job looking at secrecy laws and the expansion in the criminal code of secrecy laws. I made a range of recommendations, and I'm pleased to say the government accepted almost all of them, about getting the balance right in secrecy legislation to ensure we protect genuinely harmful information from being disclosed, but that we don't damage our democracy by quelling free speech, quelling the role of the free press, and frankly, making laws that are so confusing that they're not really able to be applied. Now I'm looking at SLADE, which is a catchy way of saying the Surveillance Legislation Identify and Disrupt Act, which is a bit of a mouthful, which is really about some fascinating police and Australian Criminal Intelligence Commission powers to do what the Parliament called new and novel things. Now, again, new and novel are words that should make every lawyer nervous, and I think they made the Parliamentary Committee a tiny bit nervous because they asked me to review those as well. And they're interesting in the electronic space they're also world-leading, another key word the Parliamentary Committee used, which should make everybody a little nervous, because they allow disruption. Now, disruption's a normal thing. Intelligence agencies do it, police do it. But when you do disruption by doing something that's otherwise a crime, you're moving into a different area. Driving around in a marked patrol car, talking to the parents of a wayward teenager. These are disruptions. Asking a diplomat to leave the country before you expel them, that's a disruption. But going online, forming a view as a police officer that a crime's been committed and getting a warrant to damage, disrupt, destroy, change or alter a computer's data is in a different realm. And it's a really challenging area because the police have made some good cases as to where they might need to use that power when nothing else would be effective. But the law, of course, is a lot broader than that. There's also another really interesting warrant in that space called the network activity warrant, because traditionally warrants have been sort of person by person, bad guy by bad guy, someone who's reasonably suspected of engaging in a crime. Well, it's really hard to know who's doing what on the internet. Layers of encryption, layers of routing, makes it really difficult to even see where you are and who's there. So this warrant enables you to get a single warrant to get a whole network of people who are electronically connected. That's a pretty broad concept. You know, my mother's on Signal. I'm pretty sure there are people on Signal selling drugs, not my mother. Does that make them electronically connected? In the effort to make this power usable by police, have we made it too broad? That's a question that I'm looking at. And as someone mentioned, the issuing of warrants. Our system for issuing warrants dates back to magistrates and justices of the peace issuing warrants for people to search a house. Well, you know, you can usually tell when the police are searching your house. They serve the warrant on you. You can challenge it in court. If they're taking over your online account or searching your online data, if they're doing it well, you'll never know. And some of these powers can't even be used as evidence, even if the police wanted to. So the chance of it ever coming before a court, notwithstanding the constitutional principles, is frankly minuscule. So are the safeguards that were set up for those magistrates issuing search warrants actually sufficient? And do our administrative review tribunal members, who are very diligent and dedicated tax lawyers, veterans affairs lawyers, good at weighing things and making decisions, do they know enough about technology to make a good judgment on the risk of unintended consequences from a data disruption? Maybe we need a new system. So that's kind of keeping me busy at the moment. And then I've also got a second team, in case you think my office is busy. When I say team, there's only 6 lawyers. So the other half of the office, the other 3, some of which are here, hi guys, are working on all of our espionage, foreign interference, sabotage and trade secrets laws, which Dom spoke about and cares a great deal about, to look at whether they're working. Because we got through the whole Cold War without a single espionage prosecution. We expelled a lot of diplomats. In fact, since we enacted these laws in 2021, we've had 1 prosecution for foreign interference. We've got another 2 on foot. But the Director General's talking about vast numbers of spies and disruptions, but there's not many prosecutions. Why is that? Perhaps the law actually isn't the answer. As Danielle said, more law isn't always the answer. And as much as I love law and love lawyers, sometimes the law doesn't do everything, even in the national security space, particularly when you intersect national security and international relations. We've expelled diplomats for years. If we start prosecuting them, what's going to happen to the Australian spies that get quietly exited from other countries? The law of reciprocity, or the practice of reciprocity. And then, in case it was getting dull in my office, the next review we're starting is the definition of terrorism itself. So in 2001 or 2002, not long after the 9/11 attacks, we all thought we knew what terrorism was. It was terrifying. It was terrible. It was attacks on buildings. Not long after we had the Bali bombings. And we have a legislative decision. It's a long and complex, well, it's only a page and a half of a definition. It's fairly long and complex. But is it fit for purpose today? Are the motive elements working? In the early 2000s, we knew that something was motivated by an ideology because Al-Qaeda would tell us they'd motivated an attack or they'd orchestrated an attack. When a teenager online is radicalized by sort of a mixed bag of violent stuff, is that an ideology that the courts can identify and say the person's motivated by? What does it mean in our modern multicultural Australia to have the word religion in our definition of terrorism? There are a whole bunch of questions. And there are a whole bunch of reasons we like to use the word terrorism. Sometimes we like to use it to express our horror, to describe something that's unimaginably awful. The Southport killings in the UK, the killing of children in a dance class. It's hard to think of anything more repulsive. And terrorism is a word we want to use to describe repulsive things. But as a lawyer, we need to be a bit more precise. Because when we use the word terrorism, we invoke not only a huge range of police and security agency powers, but a huge number of changes to our fundamental legal principles. We change the presumption of innocence by changing the bail laws when we talk about terrorism. We change the idea that when you've done your time, you're free to go when we talk about terrorism. We have powers that let you question and detain people who you do not suspect of committing a crime. So we have to be careful when we use this word because of the legal consequences. It's tempting to use it for emotional reasons. It's also tempting to use it for resource reasons. There's lots of money attached to counterterrorism. There's lots of money attached to diversion programs. But actually, that's not a good reason either. Where we spend money is a policy and political decision. It doesn't have to be defined and driven by the law. So I don't know the answers yet, but I do know that's going to be an interesting review. Watch out for jobs being advertised in my office when they come up. So the work of the National Security Legislation Monitor intersects with many areas of this book, but there's also things in the book that we don't deal with, including the law of the sea, thank you, and a range of other things. And there's heaps of things that are emerging. As I said earlier, I wish there had been a book like this 20 years ago when I started working in the field, because I think we can become, just a few lawyers, not all of them, can become a tiny bit narrow in our focus. And having this kind of interdisciplinary book reminds us to think a bit more broadly about what we're doing and to engage with a broader range of people. So I definitely commend this book to you and all of the chapters, not just chapter 3. And I want us to think about what role law can play, where the law goes too far and what the law can't usefully do, and to think about the safeguards and review mechanisms. As Rebecca said, for centuries, the courts have been the ones that are our boundary guardians for the executive and the judiciary, keeping the judiciary separate from the executive. It's blurring with warrants. It's blurring with detention. It's blurring with some of these powers like authorising data. The questions have been asked today about how do we ensure that our policymakers, our parliamentarians make the best decisions? How do we ensure our judges and warrant issuers make the best decisions without infringing on their independence? It's incredibly important in a democracy that it's actually the elected people who make the decisions, not the executive. It's actually incredibly important in a judiciary that it's the judges that make the decisions based on contestable and tested evidence. I have strong views about secret evidence, but we'll leave that for another day. So I commend the book and I encourage you to think broadly about national security law and to think about its role and its limits. And I really thank the National Security College for doing this and doing this interdisciplinary work, for Danielle and all the cats that you've herded. But I encourage you to read the book and to engage with this topic, and I thank you for your interest in this area.